Hello, everybody, and welcome to History/Law Bite number 337, dated January the 6th, 2022. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Shelby County versus Holder, 570 U.S. 529, 2013. Before I begin, however, I'd like to formally invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A., and in addition to that, please also click on the little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. You're the best. So again, this video is entitled Shelby County versus Holder, 2013. Shelby County versus Holder, if you've never heard of this case, it was a landmark U.S. Supreme Court decision on the constitutionality of two provisions of the Voting Rights Act of 1965, specifically Sections 4B and Section 5. So we begin the same way the U.S. Supreme Court does. All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. We'll hear argument first this morning in Case 1296, Shelby County versus Holder. Mr. Chief Justice, and may it please the court, we now move to the facts of Shelby County versus Holder. In the landmark Voting Rights Act of 1965, Section 5 contains a preclearance requirement for certain states and local governments to obtain approval from either the U.S. Attorney General or the U.S. District Court for the District of Columbia before making any substantive changes to their voting laws or practices before they can be enforced. Preclearance is required to ensure that those changes do not deny or abridge the right to vote on account of race, color, or membership in a language minority group. Thus, before Shelby County versus Holder, jurisdictions that were subject to preclearance in this format were not allowed to alter any of their voting laws unless they had obtained approval from either the Justice Department or the U.S. District Court for the District of Columbia. All right, it was a very, very powerful limitation on their state police power. All right, they had to give the green light before any of those changes could take effect. All right, they presented the changes, and then the Justice Department or the U.S. District Court would have to approve them. All right, just making sure we're all on the same page. Next, Section 4B contains the specific coverage formula determining which jurisdictions are subject to the preclearance in Section 5 based on their histories with discriminatory voting practices. Specifically, Section 4B's formula covered jurisdictions that, quote, as of November 1964, November 1968, or November 1972, maintained a prohibited test or device as a condition of registering to vote or voting and had a voting age population of which less than 50% either were registered to vote or actually voted in that year's presidential election, end quote. For reference purposes, Section 4A provides the guidelines for covered jurisdictions which have made sufficient progress in ending voter discrimination practices to bail out of the preclearance requirement. In a litany of cases since 1966, in the matter of South Carolina versus Katzenbach, the Supreme Court has sustained these requirements in accordance with congressional power to enforce the 15th Amendment to the U.S. Constitution. Section 5's preclearance requirement initially only had a 5-year lifespan, but subsequent amendments in 1970, 75, and 82 reauthorized it. The reauthorizations in 1970 and 75 would also serve to update the coverage formula. The Supreme Court upheld the reauthorizations in 3 separate cases, one in 1973, 1980, and 1999. In 2006, Congress reauthorized Section 5 of the Voting Rights Act for another 25 years, but left the 1975 coverage formula undisturbed. An important precedent to Shelby, Northwest Austin Municipal Utility District No. 1 versus Holder, 2009, held that jurisdictions which do not register voters had the right to file suit to bail out of preclearance coverage. Petitioners in that case also challenged the constitutionality of Section 5, but the court declined to address the constitutionality of that section. That brings us to the immediate facts of Shelby County versus Holder. Petitioner Shelby County, located in the state of Alabama, a covered jurisdiction entirely, sued U.S. Attorney General Eric Holder in the U.S. District Court for the District of Columbia. They sought a declaratory judgment that both Sections 4B and 5 of the Voting Rights Act of 1965 were facially unconstitutional and requested a permanent injunction against the enforcement of these provisions. On September 21, 2011, Judge John Bates, who, by the way, was a George W. Bush appointee, sustained the constitutionality of both sections of the Act, ruling that Congress had sufficient evidence before them in 2006 to reauthorize both Sections 5 and 4B with its coverage formula accordingly. On appeal to the U.S. Court of Appeals for the District of Columbia, that court sustained the holding of the U.S. District Court. On May 18, 2012, the judges sustained the constitutionality of Sections 5 and 4B, holding that Congress was indeed justified in holding that Section 2 in itself, allowing litigation, was inadequate in protecting minority voters, and that Section 5 was still necessary, as was the coverage formula in Section 4B. Real quick, Section 2 is another section of the Voting Rights Act, another potent artery that allows for litigation when areas have been shown to have engaged in discriminatory voting practices, all right? Section 2 is another means of challenging voter discrimination under the Voting Rights Act of 1965. More on Section 2 later on, however. After losing in the lower courts, petitioners sought review in the Supreme Court of the United States, where certiorari was granted on November 9, 2012. At oral argument on February 27, 2013, counsel for Shelby County argued that the 2006 Congressional reauthorization of Section 5 under the existing coverage formula in Section 4B of the Voting Rights Act exceeded their authority under the 14th and 15th Amendments, and thus violated both the 10th Amendment and Article 4 of the Constitution. They based these contentions on the fact that the coverage formula used in 2006 was based on 40-year-old data that did not reflect the current situation in the covered states and thus was not constitutionally permissible in restricting the sovereign power of the states. Counsel for Respondent Holder argued that Congress's 2006 reauthorization of Section 5 under the coverage formula in Section 4B was indeed justified, given the effectiveness of Section 5 in inhibiting discriminatory legislation, decreasing disparities in voter registration, and because of the less effective power of Section 2 in obtaining similar results. Needless to say, this was a very controversial case, drawing media coverage from across the nation and attracting the attention of millions. 4 states which were in some form covered by preclearance, New York, Mississippi, North Carolina, and California, ironically, filed a brief supporting Section 5, contending that it imposed no burden upon them. So the issue facing the justices in this case was this. Did Congress's reauthorization of Section 5 under the dated coverage formula in Section 4B exceed their power under the 14th and 15th Amendments and thus violate the 10th Amendment and Article 4 of the Constitution? The answer to that question? Yes. On June 25th, 2013, In a 5-4 opinion authored by Chief Justice John Roberts, the court struck down Section 4B of the Voting Rights Act of 1965 as unconstitutional. In an opinion joined by Justices Anthony Kennedy, Antonin Scalia, and Clarence Thomas, Roberts' opinion held that because of Section 4B's outdated coverage formula, it exceeded Congress's power of enforcement under the 14th and 15th Amendments to the Constitution. The coverage formula violated the principles of federalism protected by the 10th Amendment and the equal sovereignty of the states in Article 4 of the Constitution, because it was based on 40-year-old data that had no logical connection to the present day and was unresponsive to current needs. Congress could not subject states to preclearance based on past discrimination. The country has changed, according to Roberts, since the last formula update, and thus legislation enacted by Congress to remedy the problem of voting discrimination had to speak to current conditions. The 15th Amendment was not designed to punish for the past, but to provide for a better future. Roberts made it clear that his opinion in no way affected Section 2 of the Voting Rights Act, again allowing for litigation for instances of voting discrimination, nor Section 5 itself. So the opinion didn't touch Section 2 or Section 5. Congress was able to draft another coverage formula based on current conditions, but such a formula would essentially be a prerequisite in determining whether or not such measures were necessary in justifying such an extraordinary departure from the traditional relations between the states and the federal government. Justice Clarence Thomas filed an opinion concurring in the judgment, and Justice Ruth Bader Ginsburg filed a dissenting opinion that was joined by Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan. So we give you a cheat sheet Cliff Notes summary of the opinion in Shelby County versus Holder. Listen up. Section 4B of the Voting Rights Act of 1965 is unconstitutional. This is so because the coverage formula used in the section was nearly 40 years old with no logical connection to the present day and did not serve current needs. Preclearance under these conditions thus exceeded Congress's enforcement powers under the 14th and 15th Amendments, conflicted with the reserved power of the states under the 10th Amendment, and the required equal treatment of the states in Article 4 of the Constitution. So now we move to Roberts' majority opinion and the highlights. The Voting Rights Act of 1965 was enacted to address entrenched racial discrimination in voting, an insidious and pervasive evil which had perpetuated many parts of the country through unremitting and ingenious defiance of the Constitution. As a result, Section 2 of the Act, which bans any standard practice or procedure that results in denial or abridgment of the right of any citizen to vote on account of race or color, applies nationwide, is permanent and is not an issue in this case. Other sections apply only to some parts of the country. Section 4 of the Act provides the coverage formula, defining the covered jurisdictions as states or political subdivisions that maintain tests or devices as prerequisites to voting and had low voter registration or turnout in the 1960s and early 1970s. In those covered jurisdictions, Section 5 of the Act provided that no change in voting procedures can take effect until approved by specified federal authorities in Washington. Such approval is known as preclearance. Petitioner Shelby County in the covered jurisdiction of Alabama sued the Attorney General in Federal District Court in Washington, D.C., seeking a declaratory judgment that Sections 4B and 5 are facially unconstitutional, as well as a permanent injunction against their enforcement. The District Court upheld the act, finding the evidence before Congress in 2006 was sufficient to justify reauthorizing Section 5 and continuing Section 4B's coverage formula. The D.C. Circuit affirmed. After surveying the evidence in the record, that court accepted Congress's conclusion that Section 2 litigation remained inadequate in the covered jurisdictions to protect the rights of minority voters. That Section 5 was therefore still necessary, and that the coverage formula continued to pass constitutional muster. Held accordingly that Section 4 of the Voting Rights Act is unconstitutional. Its formula can no longer be used as a basis for subjecting jurisdictions to preclearance. In Northwest Austin, this court noted that the Voting Rights Act imposes current burdens and must be justified by current needs, and concluded that a departure from the fundamental principle of equal sovereignty requires a showing that a statute's disparate geographic coverage is sufficiently related to the problem that it targets. These basic principles guide review of the question presented here. State legislation may not contravene federal law. States retain broad autonomy, however, in structuring their governments and pursuing legislative objectives. Indeed, the 10th Amendment reserves to the states all powers not specifically granted to the federal government, including the power to regulate elections. There is also a fundamental principle of equal sovereignty among the states, which is highly pertinent in assessing disparate treatment of states. The Voting Rights Act sharply departs from these basic principles. It requires states to beseech the federal government for permission to implement laws that they would otherwise have the right to enact and execute on their own. And despite the tradition of equal sovereignty, the act applies only to 9 states, and additional counties. That is why in 1966, this court described the act as stringent and potent. Katzenbach versus U.S. All right. Katzenbach versus South Carolina versus Katzenbach. All right. The court nonetheless upheld the act, concluding that such an uncommon exercise of congressional power could be justified by exceptional conditions. In 1966, these departures were justified by the blight of racial discrimination in voting that had infected the electoral process in parts of our country for nearly a century. At that time, the coverage formula, the means of linking the exercise of the unprecedented authority with the problem that warranted it, made sense. The act was limited to areas where Congress found evidence of actual voting discrimination, and the covered jurisdictions shared 2 characteristics: the use of tests and devices for voter registration, and the voting rate in the 1964 presidential election at least 12 points below the national average. The court explained that tests and devices are relevant to voting discrimination because of their long history as a tool for perpetuating the evil. A low voting rate is pertinent for the obvious reason that widespread disenfranchisement must inevitably affect the actual number of voters. The court therefore concluded that the coverage formula was rational in both practice and theory. Nearly 50 years later, things have changed dramatically. Largely because of the Voting Rights Act, voter turnout and registration rates in covered jurisdictions now approach parity. Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels. The tests and devices that block ballot access have been forbidden nationwide for over 40 years, yet the Act has not eased Section 5's restrictions or narrowed the scope of Section 4's coverage formula along the way. Instead, those extraordinary and unprecedented features have been reauthorized as if nothing has changed, and they have grown even stronger. Because Section 5 only applies to those jurisdictions singled out by Section 4, the court turns to consider that provision. Section 4B's formula is unconstitutional in light of current conditions. The government attempts to defend the formula on the grounds that it is reverse engineered. Congress identified the jurisdictions to be covered and then came up with criteria to describe them. But history did not end in 1965. In assessing the current need for a preclearance system, treating states differently from one another today, history since 1965 cannot be ignored. The 15th Amendment is not designed to punish for the past. Its purpose is to ensure a better future. To serve that purpose, Congress, if it is to divide the states, must identify those jurisdictions to be singled out on a basis that makes light and makes sense of current conditions. Respondents also rely heavily on data from the record compiled by Congress before reauthorizing the Act. Regardless of how one looks at that record, no one can fairly say that it shows anything approaching the pervasive, flagrant, widespread, and rampant discrimination that clearly distinguished the covered jurisdictions from the rest of the country in 1965. Congress did not use that record to fashion a coverage formula based on current conditions. It instead reenacted a formula based on 40-year-old facts having no logical relation to the present day. Our decision in no way affects the permanent nationwide ban on racial discrimination in voting found in Section 2. We issue no holding on Section 5 itself, only on the coverage formula. Congress may draft another formula based on current conditions. Such a formula is an initial prerequisite to a determination that exceptional conditions still exist, justifying such an extraordinary departure from the traditional course of relations between the states and the federal government. Our country has changed, and while any racial discrimination in voting is too much, Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions. So we now move to the concurring opinion by Justice Clarence Thomas. I join the court's opinion in full, but write separately to explain that I would find Section 5 of the Voting Rights Act unconstitutional as well. The court's opinion sets forth the reasons the Voting Rights Act of 1965 employed extraordinary measures to address an extraordinary problem. In the face of unremitting and ingenious defiance of citizens' constitutionally protected right to vote, Section 5 was necessary to give effect to the 15th Amendment in particular regions of the country. Though Section 5's preclearance requirement represented a sharp departure from basic principles of federalism and the equal sovereignty of the states, the court upheld the measure against early constitutional challenges because it was necessary at the time to address voting discrimination where it persisted on a pervasive scale. Today, our nation has changed. The conditions that originally justified Section 5 no longer characterize voting in the covered jurisdictions. As the court explains, voter turnout and registration rates now approach parity. Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels. In spite of these improvements, however, Congress increased the already significant burdens of Section 5 following its reenactment in 2006. The Voting Rights Act was amended to prohibit more conduct than before. Section 5 now forbids voting changes with any discriminatory purpose, as well as voting changes that diminish the ability of citizens on account of race, color, or language minority status to elect their preferred candidates of choice. While the pre-2006 version of the Act went well beyond protection guaranteed in the Constitution, it now goes even further. However one aggregates the data compiled by Congress, it cannot justify the considerable burdens created by Section 5. Right? The extensive pattern of discrimination that led the court to previously uphold Section 5 as enforcing the 15th Amendment no longer exists. Okay? While the court claims to issue no holding on Section 5 itself, its own opinion compellingly demonstrates that Congress has failed to justify current burdens with a record demonstrating current needs. By leaving the inevitable conclusion unstated, the court needlessly prolongs the demise of that provision. For the reasons stated in the court's opinion, I would find Section 5 unconstitutional. So now we move to Justice Ginsburg's dissent, joined by Justice Breyer, Sotomayor, and Justice Kagan. In the court's view, the very success of Section 5 of the Voting Rights Act demands its dormancy. Congress was of another mind. Recognizing that large progress has been made, Congress determined, based on a voluminous record, that the scourge of discrimination was not yet eliminated. The question in this case presents who decides whether, as currently operative, Section 5 remains justifiable. This court or a Congress charged with the obligation to enforce the post-Civil War amendments by appropriate legislation. With overwhelming support in both houses, Congress concluded that for two prime reasons, Section 5 should continue in force, unabated. First, continuance would facilitate completion of the impressive gains thus far made, and second, continuance would guard against backsliding. Those assessments were well within Congress's province to make and should elicit this court's unwavering approbation. Voting discrimination still exists. No one doubts that. But the court today terminates the remedy that proved to be best suited to block that discrimination. The Voting Rights Act of 1965 has worked to combat voting discrimination where other remedies have been tried and failed. Particularly effective is the Voting Rights Act requirement of federal preclearance for all changes to voting laws in the regions of the country with the most aggravated records of rank discrimination against minority groups. There is no question, however, that the covered jurisdictions here have a unique history of problems with racial discrimination in voting. Consideration of this long history, still in living memory, was altogether appropriate. The court criticizes Congress for failing to recognize that history did not end in 1965. But the court ignores that what's past is prologue, and those who cannot remember the past are condemned to repeat it. Congress was especially mindful of the need to reinforce the gains made and to prevent backsliding. 2006 reauthorization of Section 5 and Section 2B9. Of particular importance, even after 40 years and thousands of discriminatory changes blocked by clearance, conditions in the covered jurisdictions demonstrated that the formula was still justified by current needs. Because in its view, the provision is not based on current conditions, the court strikes down 4B's coverage. It discounts, however, that one such condition was the preclearance remedy in place in the covered jurisdictions, a remedy Congress designed to catch both discrimination before it causes harm and to guard against a return to old ways. 2006 reauthorization, all right. Volumes of evidence supported Congress's determination that the prospect of retrogression was real. Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. That's a landmark line from her dissent there. Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing out your umbrella in a rainstorm because you're not getting wet. Of course you're not getting wet because the umbrella is protecting you. Section 5 is prohibiting the discrimination, but the court gets rid of it shamefully, right? Beyond question, the Voting Rights Act is no ordinary legislation. It is extraordinary because Congress embarked on a mission long delayed and of extraordinary importance to realize the purpose and promise of the 15th Amendment. For a half century, a concerted effort has been made to end racial discrimination in voting. Thanks to the Voting Rights Act, progress once the subject of a dream has been achieved and continues to be made. All right? The record supporting the 2006 reauthorization of the Voting Rights Act is also extraordinary. It was described by the chairman of the House Judiciary Committee as one of the most extensive considerations of any piece of legislation that the Congress has dealt with in the 27 and a half years he had served in the House. Right? After exhausting evidence gathering and deliberative process, Congress reauthorized the Voting Rights Act, including the coverage provision, with overwhelming bipartisan support. It was the judgment of Congress that 40 years has not been a sufficient amount of time to eliminate the vestiges of discrimination following nearly 100 years of disregard for the dictates of the 15th Amendment and to ensure that the right of all citizens to vote is protected as guaranteed by the Constitution. The determination of the body empowered to enforce the Civil War amendments by appropriate legislation merits this court's utmost respect. In my judgment, the court errs egregiously by overriding Congress's decision. For the reasons stated, I would affirm the judgment of the Court of Appeals. So the judgment of the court in this case, U.S. Court of Appeals for the District of Columbia, reversed. The laws applied here, Amendments 14, 15, 10, and Article 4 of the U.S. Constitution, as well as the Voting Rights Act of 1965. So that takes us to the legacy of Shelby County. So Shelby County versus Holder was a very controversial decision, one that is arguably in the living memory of most people. That drew just as much praise as it did contempt. All right. Here, the court gutted a major artery of the Voting Rights Act of 1965, Section 4B, and its coverage formula for specific jurisdictions. And in doing so, left Section 5 effectively useless until Congress adopts a new formula for preclearance. Numerous reactions came from officials across the political spectrum. President Barack Obama and Attorney General Eric Holder both expressed deep disagreement with the court's decision, and the president would call upon Congress to move quickly to protect voting rights and repair the damage that the court had wrought on the Voting Rights Act. Additionally, then Senate Majority Leader Harry Reid stated that the Democrats were concerned with the ruling, given Republicans' efforts to suppress votes in the 2012 presidential election. Representative John Lewis of Georgia, who participated in Bloody Sunday in 1965, which was the event that got Congress moving on the Voting Rights Act, and who was also present when President Johnson signed the Voting Rights Act in August of 1965, chastised the decision as ignoring the country's history of racism. Republicans were more varied in their response to the decision. Some gave it a lot of approval and praise. Others were not in agreement with it at all. But Democratic opposition to the decision was virtually unanimous, right? So as one might expect, the immediate effect of Shelby County versus Holder was the adoption of hundreds of new election laws in the states, many of which would have previously required preclearance before taking effect. Since Shelby, more than 1,000 polling places have closed. Not surprisingly, most of these have been in minority, low-income communities. Additionally, states have adopted new laws permitting purges from voter rolls and blatant racial gerrymandering, as evidenced in the cases of Husted versus Randolph Institute, 2018, and Abbott versus Perez in 2018 as well. The damage done from Shelby and its progeny is very evident, and the current conservative-dominated Supreme Court seems more willing than ever to tolerate laws that enable voter suppression, directly and indirectly, and as well as dilute the force of the remaining vital artery in this regard, Section 2, as we've discussed, all right, in the case of Brnovich versus Democratic National Committee in 2021. So, just for some perspective on the 2006 reauthorization of the Voting Rights Act, the House and Senate Judiciary Committee held 21 hearings, heard from scores of witnesses, received a number of investigative reports, and other written documentations of continuing discrimination in the covered jurisdictions. In all, the legislative record Congress compiled filled more than 15,000 pages. 15,000 pages. That's a lot. The compilation presents countless examples of flagrant racial discrimination since the last reauthorization. Congress also brought to light systemic evidence that intentional racial discrimination in voting remains so serious and widespread in covered jurisdictions that Section 5 preclearance is still needed. All right? Congress had more than enough evidence to see that Section 5 was still needed, and the Supreme Court should have deferred to the judgment of Congress in this situation, as it had in virtually every other circumstance in cases challenging the Voting Rights Act or any of its provisions. So, in conclusion, voter suppression is as old as America itself. All right, history has proven in so many individual instances that ballot access in this country truly remains at the mercy of the powers that be. States and local governments cannot be trusted to protect voting rights, which is why strong federal laws such as the Voting Rights Act of 1965 are crucial in enforcing the right to vote. One will often hear the false claims of voter fraud or lack of election integrity, but these are just catchwords for jurisdictions to be able to enact facially neutral voting restrictions that have a clearly discriminatory effect. States can no longer enact literacy tests, poll taxes, and grandfather clauses, no. But new forms of Jim Crow include very restrictive ID laws, polling place closures, and voter roll purging. The goal is clear regardless of where these things happen, both in the North and the South, and that is to reduce minority participation in the electoral process. Not surprisingly, most if not all of these restrictive laws have been enacted by Republicans. Wisely, Republicans know that when people vote, Democrats win. And therefore, they, Republicans, are going to do everything in their human power to inhibit the ability of Democratic voters. I mean, that's just the bottom line. Republicans know they will not win when people come out to vote. Okay? And so they do what they can to suppress the Democratic electorate. All right? They're certainly not going to suppress their own electorate. What sense would that make? So the bottom line is that the players might change, but the game is the same. All right? The game has been in existence since the country's birth. The players are different, but the game is the same. So to sum of it all, know the voting laws in your jurisdiction. Be aware of the type of ID you need to cast ballots. Know your polling place. Know how you're going to get there. Make sure you haven't been purged from the voter roll. And make sure your registration is active, all right? And if you intend to vote in person, make sure that that is verified as opposed to voting by way of absentee ballot. Because guess what? If you're in the system as having to vote by absentee ballot and you go to the polls in person, they're going to turn you away because they've already sent you an absentee ballot, all right? 9 chances out of 10, all right? So the right to vote in America is under siege, probably more now than what it has ever been, okay? Facilitated by a conservative Supreme Court that could not care less about minority voter participation, all right? Unlike in the past, however, you have an abundant amount of knowledge, okay, to get around these obstacles, all right? It is easier to register to vote than ever before, all right? And easier to cast ballots than ever before, okay? So there's no excuse in allowing your state to steal your right to vote. Protect it like you would your life savings. And protect the democracy in America that so many people take for granted. Democracy that so many people have died for. So I thank you so much for listening to this History/Law Bite, number 337, entitled Shelby County versus Holder, and properly referenced as 570 U.S. 529, 2013. If you have any questions or controversies, leave them down below and I'll be happy to answer them. If you like this video, gain some insight from it, drop me a like. That would be graciously appreciated. And if you've not subscribed to my YouTube channel at this point, please do so now. Juarez Lee Shelton, M.A. Before I leave you, I'm going to give you the summary of the opinion in Shelby County one more time, so listen up. Section 4B of the Voting Rights Act of 1965 is unconstitutional. This is so because the coverage formula used in that section was nearly 40 years old with no logical connection to the present day and did not serve current needs. Preclearance under these conditions thus exceeded Congress's enforcement powers under the 14th and 15th Amendments, as well as conflicted with the reserved powers of the states under the 10th Amendment and the required equal treatment of the states in Article 4 of the Constitution. So that's the summary. So I conclude with the very wise words of one of my teaching role models, Mr. George Feeney. Believe in yourself, dream, try, do good. And I leave you with my own personal words with respect to this case. Take care, stay safe out there, be blessed, and get out there and vote when it's time for you to do so. Have a good one.